There's a category of military attorney that we don't often talk about on this podcast. We usually focus on military justice, looking at what government and defense counsel, appellate counsel, or appellate courts argue and conclude. But there are lots of lawyers in the DoD that operate beyond the courtroom and outside the bounds of litigation. Relevant to today's episode, there are lawyers providing operational support. They work on issues involving treaty compliance, the law of war, detainee operations, rules of engagement, the law of the sea, and non-lethal weapons and force. They have other tasks that they handle, but those are probably the ones that mean the most to what we're looking at for a few episodes. When Staff Sergeant Bales, the subject of today's episode, slipped away from his post and took the lives of local civilians, he almost certainly violated the ops law guidance, rules of engagement, and law of war. This is Conduct and Becoming. I'm Erin, and I'm your host. As a quick reminder and refresher from the last episode, I am unbothered and unswayed by the suggestion that I avoid the political stuff, and we're transitioning into a multiple episode run on war crimes. I don't really have any interest in breaking any individual case into multiple episodes because absent obtaining the entire record of trial and copies of exhibits, there often isn't that level of information actually available. But as a recovering sorority girl, I do love a theme, so I'm slinging us into this one. As with most legal analysis, it's probably the most helpful to define what a war crime is before we start looking at cases or trying to decide if certain actions do or do not qualify. Generally speaking, a war crime is a violation of international humanitarian law, so violations committed during a time of war. The Hague and Geneva Conventions exist to give all governments a framework to limit the barbarity of conflict and to hopefully minimize the impact to innocent civilian populations trying to do the difficult work of surviving in a war zone. But the laws of war also serve to protect combatants who are captured. And maybe it's kind of generally tempting to think, oh, but how are American service members supposed to know what specifically constitutes a war crime? So I think maybe a fair starting point might be the Military Commissions Act. Section 950T throws out a list of crimes triable by military commissions, including attacking civilians, attacking civilian objects, pillaging, denying quarter, taking hostages, employing chemical weapons or poisons, torture, mutilation, maiming or killing a protected person, murder in violation of the law of war, and desecrating a dead body. There are others included in that list in Section 950T, but I think this is a really good starting point. A list of actions the United States considers to be a crime if committed against us. The United States is not blameless in its history, and it has violated the very statutes we seek to apply to enemy combatants. But history can also perhaps give us a false sense of security because no American has been prosecuted by the International Criminal Court. The United States has passed an entire law to restrict U.S. cooperation with the ICC if and when they seek to prosecute the U.S. or allied personnel detained by the court. And that's not to say that the court wouldn't pursue charges against American nationals committing war crimes within the ICC's jurisdiction. The law just dictates that our government is supposed to do their best to get that American national back ASAP. There are lots of interesting thought papers out there on all of this, but it's a concept that doesn't feel entirely unfamiliar. Status of forces agreements, like the ones operating in Japan, are agreements that shape the way that military service members interact with host nations overseas. And those SOFA agreements often serve to try and buffer Americans from overseas judicial systems. And lest you be concerned that I'm just pulling explanations from the ether, when Trump signed an executive order in 2020 calling international criminal court claims to jurisdiction over U.S. military personnel illegitimate, Secretary Esper asserted that the United States has a sovereign right to investigate and address any alleged violations of the laws of war by American service members. And, he argued, there was no other force so committed to compliance with the laws of war or a better track record of investigating and prosecuting the criminal actions of its own service members. I'll note, and you can as well because of course it's linked in the show notes, that the article on the Department of Defense website does bear a ribbon at the top that signals it's hosted in a historical collection and that some of the information contained within might be outdated. That might be one way to square historical commitments with the current Secretary of Defense asserting that the rules of engagement are, quote, stupid, politically correct, and woke. What a choice to set up a train of thought that ends in the laws of war being woke ideology, and a thing that one of the best funded and heavily armed militaries on the planet can just ignore. We wouldn't want the US to end up doing something objectively horrific like double-tapping a school. I suspect, given how high tensions currently are, that it may be prudent to look at some more historical examples of violations of the Military Commissions Act and the laws of war, instead of focusing on unlitigated current events. When service members are charged with committing a war crime, it's not that they're being charged with one count of committing a war crime and X counts of something else. They're charged for the base criminal act that they commit. Let's look at the United States versus Bales to ground our discussion. The factual details of this case are upsetting, and they do get graphic. I think we could talk about what happened in broad strokes, but I also think describing the facts generally and saying that Bales shot and killed a certain number of civilians sanitizes the details in a way that I don't think is productive for a discussion of what makes a war crime. Stripping the details down is a gloss I don't think we can fairly apply. On March 11, 2012, Staff Sergeant Robert Bales slipped away from Village Stability Platform Belem Bay in Kandahar and visited 2 nearby Afghan villages carrying his Army-issue rifle, pistol, night vision device, and extra ammunition. Bales, who enlisted on September 12, 2001, was in the midst of his 4th combat tour. His first 3 were in Iraq. He wasn't in a small Afghan village to see the sights in the early morning hours. He wasn't there to borrow a cup of flour from the post's neighbors. Instead, in both villages, he opened fire, ultimately shooting 22 Afghan civilians in their homes, killing 16 of them. In the first village, he killed 2 elderly men, 1 elderly woman, and a child. He assaulted an additional 6 people, including 1 woman and 4 children. After his initial rampage, Bales realized that he'd been imprudent when he packed his spare ammunition. He was running low and his night wasn't over, so he returned to his post to pick up bullets and a grenade launcher. He then visited a second village, entering the home of a sleeping family. Bales pulled a man from the home into a courtyard and shot him at close range with his family as witnesses. Then Bales entered another home, set his rifle for 3-round bursts, and shot 10 people in the head at close range. Just 1 was a young man. The rest were women and children. He found a lantern full of kerosene, dumped the fuel over the bodies of the 10 people he just murdered, and set them on fire. On his way out of the house, Bales shot an elderly woman in the chest and head with his pistol. But the gunshots did not kill her. He waited until she was lying on the floor and crushed her skull by stomping on her with his boot. At some point in this fracas, Bales stole a blue decorative fabric from one of the homes he invaded and put it on across his back. I can't find any more description as to how he wore that, whether it was draped like a scarf or a cape. Then Bales began his walk home. As he walked, victims from the first village made it to forward operating base Zangabad, where military, medics, and doctors rushed to treat them. When Bales made it back to his post, he was intercepted by 3 of his colleagues. If he was coming back for still more supplies, they at least stopped him from a 3rd massacre. They seized his weapons, the blue decorative fabric, and his night vision device. Bales remained in detention, detained by 2 soldiers until special agents from Criminal Investigation Division arrived. To his guards, he explained that he thought he was doing the right thing, and he apologized for letting them down. He estimated he killed 20 Afghan civilians and said, quote, "We should have hit them harder." Agents performed a search of Bales's room and seized his computer, his accessories and clothing from the early morning massacre, and anabolic steroids they discovered hidden under the walkway outside his room. Bales blames his anti-malarial medication, Lariam or mefloquine hydrochloride, for his actions. He didn't seem to have any record of being prescribed that particular anti-malarial, instead offering an affidavit from an NCO who believed Lariam had been prescribed. No Lariam had been recovered from his room, and no one attested that they'd actually seen him consume the drug. His medical records showed that he had received an anti-malarial, but that it had been doxycycline hyclate. A bottle of doxycycline was part of the inventory in Bales's room. But doxycycline hyclate doesn't have a known side effect of vivid dreams, which is probably why it was prescribed. His argument as to what caused the rampage did not account for his admitted use of anabolic steroids or the roid rage that might come with them. And that kind of makes sense because he explicitly waived any argument regarding voluntary intoxication when he later made his plea. For what it's worth, I don't know that his claim about involuntary intoxication as a result of Lariam consumption jives with his statement to his colleagues, or to the various arguments he's made through the pendency of his case. Ultimately, Bales accepted a plea agreement in order to avoid the death penalty. He pled not guilty to attempting to impede an investigation by damaging a laptop, and guilty to 16 specifications of premeditated murder, 6 specifications of attempted murder, 1 specification of violating a lawful general order, 1 specification of wrongfully using a Schedule II controlled substance, 4 specifications of intentional infliction of grievous bodily harm, 1 specification of assault with a dangerous weapon, 1 specification of assault consummated by battery, and 1 specification of wrongfully burning bodies. All of these were violations of the Uniform Code of Military Justice, and most of them are also violations of the Military Commissions Act, attacking or murdering civilians, and desecrating bodies. So even though none of these charges are specifically listed as a war crime, it's clear that Bales pled guilty to war crimes. During the sentencing phase, Bales listened as victims made their impact statements lamenting that, as upset as Bales's mother was, she could still visit him, but they couldn't visit their lost loved ones. A father described what it was like to lose 6 of his 7 children to Bales. But Bales still tried to distance himself from his actions, despite having pled guilty. He said, quote, "I'm truly, truly sorry to those people whose families got taken away. I can't comprehend their loss. I think about it every time I look at my kids." The passive voice really bugs me in a statement that's ostensibly meant to be taking accountability. He'd already taken legal responsibility, pleading guilty, but couldn't seem to bring himself to acknowledge that these victims were not taken away as though by some natural disaster, but rather that he planned and executed their murders. He then went on to apologize to his army brethren. A panel sentenced Bales to confinement for life without the possibility of parole, forfeiture of all pay and allowances, reduction from E6 to E1, and a dishonorable discharge. I think Bales got a 6-month reprieve from the forfeiture for the benefit of his family. Bales has appealed to a wide swath of appellate courts, starting with the Army Court of Criminal Appeals, which determined he was not due any relief. To the ACCA, he'd argued that he was entitled to a new sentencing hearing because of alleged due process and discovery violations. He argued that the government committed fraud upon the court-martial, citing dubious links between government witnesses, those are the people making their victim impact statements, to improvised explosive device events. In his appellate briefing, he challenged the government's sentencing argument that the civilians he murdered were, quote, innocent and farmers. He hadn't objected to that description below, challenging it only on appeal. It seems, based on the evidence available, that Bales hired an expert to red-string the witnesses, those victims making their victim impact statements, to attacks Bales, his unit, or other units endured. Knowledge of this evidence, if we want to call it that, of these unsubstantiated links, couldn't be attributed to government counsel or even to Bales. I say that because if Bales had reason to know that the elderly woman who he shot twice before stomping her to death was making, placing, or detonating IEDs, he probably would have offered that into evidence in some way. And the same goes for his other elderly victims and the children. Even if he thought that it was younger, able-bodied men that posed a threat, I think the math says he has 2 or 3 such victims. The post-court-martial report that he had made seems a pretty thinly veiled attempt to drum up a reason and a justification for murder. But you don't get to shoot people and fish around for justification later. The Court of Appeals for the Armed Forces affirmed the ACCA's ruling regarding the unsubstantiated expert claims and claims that Bales made regarding Lariam, the drug that he was not prescribed and that no one saw him take, and an involuntary intoxication defense. This all set up a run to appeal to the Supreme Court of the United States on the same red-string grounds for post-murder justification and anti-malarial involuntary intoxication. But SCOTUS denied his cert petition in June 2018. After striking out with military justice and the Supreme Court, Bales filed a petition for writ of habeas corpus in Kansas while serving his life sentence at Fort Leavenworth. A petition for writ of habeas corpus is a demand to produce the body, the petitioner, to a hearing so that they can argue their case. So they can argue that something was fundamentally wrong with the process they received and that they don't have another avenue by which to pursue redress. In his habeas petition, Bales argued that the district court should reach the merits of his appellate claim, those supposed terrorist ties and unsubstantiated Lariam allegations. He wanted to challenge the outcome of his court-martial and actually get a new one, a one in which he could enter a plea of not guilty by reason of insanity, I think due to his supposed Lariam consumption, but interestingly not on a theory of post-traumatic stress disorder or trauma responses. The district court denied his petition, holding the ACCA had considered all of his constitutional claims, and he didn't get another bite at the apple in the federal system, so he appealed to the 10th Circuit. The court considered his petition and affirmed the district court's denial, concluding the ACCA applied proper legal standards and both fully and fairly considered his challenges. Bales' attorney has indicated he will seek clemency from the current president. I consider this a fairly recent example of Americans committing war crimes. I suppose one could take some measure of comfort in knowing that the current Secretary of Defense has at least some exposure to the concept of the law of war and to war crimes. On March 13, 2026, during a press briefing with the chairman of the Joint Chiefs, that's Air Force General Dan Kane, Secretary Hegseth described a confused Iranian military and promised that in our response, quote, "We will keep pressing, we will keep pushing, keep advancing, no quarter, no mercy for our enemies." I've linked that transcript on the department's website in the show notes. And perhaps we need a little more explanation as to what that statement means. It has nothing to do with football quarters or 25-cent pieces, but it's a bit of a term of art. Or it's archaic, I'll let you decide. But for the last 120 years, the Hague Convention forbid declaring that no quarter will be given. So it's a breach of international humanitarian law to even threaten to deny quarter. And if we look back to the Military Commissions Act, Section 950T and scroll, we find that subsection 6 makes it a crime to deny quarter. It reads, "Any person subject to this chapter who, with effective command or control over subordinate groups, declares, orders, or otherwise indicates to those groups that there shall be no survivors or surrender accepted, with the intent to threaten an adversary, or to conduct hostilities such that there would be no survivors or surrender accepted, shall be punished as a military commission under this chapter." Denying quarter means we aren't going to house anyone, even if they surrender, and that they will all be killed. Saying we will keep pushing, keep advancing, no quarter, no mercy for our enemies, seems to be that threat. It remains to be seen whether the United States will exercise its sovereign right to investigate and address any alleged violation of the laws of war by American service members, or if the United States is still so committed to compliance with the laws of war, or will maintain its track record in investigating and prosecuting the criminal actions of its own. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time when we venture a little further back in time. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense or by their new preferred name, the Department of War.